Broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Welcome to today's webinar. I'm Anna Hobson from HR Simple, and I will be moderating today. Today's presenter is Frank Day from FordHarrison. The presentation will be about an hour long, and if you have any questions, please submit them in the question box, and we will get to them at the end of the webinar. If you need to view more webinars, you could go to hrsimple.com/events, and we have our own webinars posted as well as valuable resources from Chamber of Commerce to law firms that we partner with. HR Simple provides federal and state-specific manuals. We make employment law easy. Our books are written by top labor attorneys. Vacation policies, employee documentation, and how to fill out the I-9 form are just a few of the topics the manuals cover. Today's speaker, Frank Day, is also author of one of our books. You can check that out at hrsimple.com/shop. Go to federal. He is author of The Hiring, Firing, and Discipline for Employers. Frank has successfully represented national retailers, healthcare providers, and various other public.
Hey, Anna, how about this? I can do my bio really fast.
Awesome, let's do that. I'll hand things over to Frank.
Yeah, I mean, the formal bio is great, but what I have is I work at a law firm. If you're not familiar with FordHarrison, we have a national practice. We have offices all over the place. I'm actually in Memphis, but I represent clients across the country. And when a matter or an issue comes up that's outside of my specific areas of practice, my practice areas, I've got lots of partners who, I'm able to pass those off to. We handle management side labor and employment, so we're only representing employers. I think one of our guiding principles is, like, let's say, the FordHarrison promise, which is we're going to provide you the highest level legal representation available, and we're able to do it at a very cost competitive price. And it's because of we have expertise in these areas, and if it wasn't me, I can pass an issue off to someone else. But we definitely are keeping track of all the trends and developments in law, et cetera, et cetera. And so we're a full service labor and employment boutique firm, but boutique is kind of misleading because we have a very large presence and lots of lawyers. And so when it comes to labor and employment issues, we are able to handle all of those very effectively and efficiently, and really happy to be with you today. So with that, I kind of wanted to say, I'm a partner in our Memphis office. I travel, interestingly. I used to be traveling quite a bit for litigation and for helping clients with various compliance-related issues, everything from, let's say, advice and counsel to litigation. Zoom, interestingly, or GoToWebinar, whichever platform you may use, has, and COVID obviously, has gotten me a little bit more home-based, which is not a bad thing. And I still feel like it's a good platform to connect. But I'm a partner, have been for quite a while, and have a pretty diverse background, but just very happy to be talking to you today about a topic that many employers really need to be paying attention to. And if we can go to the next slide, I'll be happy to provide my contact information again. We just have a lot of material to cover today. So what's the agenda? I always like to start with that. And yeah, there's bullet points on here, but the most important thing here is the big yellow sign at the bottom of the slide. Change ahead. Change is coming. And what I'm going to talk to you about today is where some major changes are really going to be coming, and they're going to be significant. In the past, from administration to administration, in a less polarized society, the changes weren't always as, let's say, aggressive as they have been in, let's say, from flipping from one administration to the next throughout time. And so there's really a lot of changes coming, and there's a lot of signals coming from the Biden administration that show that we are looking at significant change. One thing I always feel like I should talk about when this is a program about the Biden administration, is this is not a news program. This is not about politics. This is about, our prediction as experts in labor and employment law about what the policies are likely to be, what they've announced the policies will be, and give you some updates on what we're seeing practically, so that you can begin to structure and take a proactive approach to getting yourself in a best position possible to avoid some of the pitfalls that, let's say, more aggressive investigations may bring on board. And so that's really what we're going to talk about today. It's not about politics. I'll tell you, that's just not, for what we do professionally, that's not part of it. And this program is an overview of a lot of the changes that we think are going to be coming down through federal agencies, through legislation, and possibly legislation, depending on some hurdles we have to get through. And the one thing I would also say is, so this is an overview, and to give you an overview, you're going to have some knowledge on the front end of a little bit of what I'm talking about, but I'm also going to be, just because of client demand for this information, I'm putting together other presentations that take out segments of this and do a much deeper dive on those segments. And I was talking to Anna about that. I'm doing those presentations for some of our larger multinational clients. I'm even doing them for some of our small local clients, that range anywhere from, let's say, mom and pop store to a, local pizza parlor kind of thing, where I know their issues because I know my clients well and can kind of direct them to the places where they need to focus because I know their businesses. That being said, there will be follow-up presentations that take a deeper look at some of the topics we're going to talk about today. So anyway, I think it's a good program, and I think let's just jump in. So there's federal agencies, and one of the fastest way, minus legislation, for an administration to implement change is to get the executive agencies implementing your policies and doing it quickly. So obviously you have EEOC, the Department of Labor, and the NLRB. Now, there's other ones as well, such as Department of Education. There's so many different ones that I could talk about as well. Those are a little bit more outside of my area, but I've had partners who presented on those. That being said, let's focus on these because these are the ones that have the main impact on employers. Okay, so the EEOC. Well, it's a great picture, but I don't really have anything to say other than it's the EEOC. So Anna, let's move on to the substance. Okay, so let's talk a little bit about what happened in 2020. It's really interesting. I'm not going to read this slide to you. It just shows that I put together a lot of data for you. So what's really key here? What's key is EEOC filed many fewer lawsuits last year than they had filed since 1997. They only filed 12 lawsuits where there wasn't a systemic claim and 13 systemic lawsuits. And here's what's really key. They've cleared a huge backlog of EEOC charges, and they've also focused very heavily on mediation, and they were successful in resolving a large number of claims in mediation. So charges were getting resolved earlier, faster, with less litigation by EEOC. And let's move on. So Biden's new agenda at EEOC. I can tell you right now, because what we're seeing is, in a large degree, Biden was President Obama's vice president. We are seeing a pushback to lots of the policies from the Obama administration. And we're also seeing, in some respects, the possibility of maybe a little bit more aggressive pushes on some issues than President Obama made. But we can talk about that in more detail in a minute. So we're talking about what the focus is at the EEOC. Well, there's going to be more enforcement actions. By that I mean litigation. The EEOC is being far more aggressive, in my opinion, in how they're investigating charges that, historically speaking, would be ones that would be investigated, but not investigated, let's say, they wouldn't invest the resources that they are now in investigating. And I can give you an example. I have a single charging party EEOC charge, just one person alleging sexual harassment and retaliation. EEOC, and this came down, I was told, by the regional director of litigation, has mandated that the EEOC investigator pursue it very aggressively. In this one complainant against one manager, EEOC has requested that we provide the names, phone numbers, addresses, and emails for every female employee that worked at the facility for the last 2.5 years. I mean, that's the way you investigate a pattern or practice case. And obviously I pushed back very hard. Anyway, to give you a long story short, we did end up providing them with some information about other employees, narrowed the time scope a lot, but they were looking in that case, I believe, to try to find a pattern or practice case. And this is very early in the investigation. And I would not have flagged this one as anything special. Maybe it was a glitch, maybe who knows. But one thing I can say is the investigations are going to be a lot, I believe, more, they're going to be more invested in investigations, are going to spend more resources on those. And I believe it's because they're going to be really pushing hard to find lawsuits in which they can allege pattern or practice cases, even if the complaint, the original EEOC charge, doesn't really raise those allegations. So pay equity is a huge issue under the Biden administration. As you might recall, with the Obama administration, pay equity was a big priority. They've already announced it's a big priority here too. So I'm expecting them to implement the EEO1 component 2 data in your EEO1s that has the 14 pay bands, which allows them to kind of take a little bit more of a forensic look at how salaries are, what type of money people are making in certain categories. That is really kind of important to you because generally speaking, for EEOC to bring a lawsuit, they need a complaint. They need somebody to come in and file a EEOC charge and make allegations. Well, when it comes to pay data, that's not the case. If they have this data and it looks like there's problems, they can conduct what's called a directed investigation, which means they can investigate it even if there's no charge, and they can end up processing it, moving along, and filing their own lawsuit without anybody ever complaining. So that was one concern we had when the component 2 came out, and employers understood what that meant, and they started trying to get their house in order with payroll, with pay equity audits, et cetera. And then the Trump administration came in and there was an understanding that you could back off of that. You need to be focused on pay equity. And I'm going to be doing a whole nother program on pay equity, not just the EEO1 and component 2 stuff, but a holistic approach to that. So one thing we saw was in the EEOC data, well, there was a huge focus under the Trump administration with programs focused on mediation and conciliation. Okay, that's great. Well, those programs have been canceled. These resources, we believe, I don't get to see their budget, are being reallocated to investigations and probably litigation, depending on what they find. So just giving you a heads up that that is something that needs to be on your map. And so once again, we're looking for systemic violations and ways for them to pursue. I found a little tag that said, "Hello, I'm suing you," because odds are you're not going to get sued, but the number of lawsuits that are going to be filed by EEOC are going to go up. That I can promise. Okay, moving on to the next part of our overview, and that's the Department of Labor. Let's go to the next slide. Okay, so this slide was created, I think, like a few days ago. Marty Walsh was actually confirmed yesterday. I won't spend a lot of time talking about Marty. News media can do that. From Boston, he did have some bipartisan support. He is very much, he announces the fact that he's pro-union, and he has a long history, but he's well respected in Boston. Why does this matter? I mean, he is worker friendly viewpoint, as you would expect, but he also presides now over a 39, I think it was it's more than a $39 million budget, and $11 million of that is discretionary. And so do you need to be concerned about what goes on at the DOL? Yes. Now, in addition to the $39 million budget, they also have a $25 million, a $28 billion mandatory budget. Sorry, I think I said 38 million. It's 39 billion. I actually flipped to a note because I was thinking that just doesn't seem like much. But 39 billion and 11 billion in discretionary, plus a 28 billion for their typical employees. And so a staff of over 16,000. The Department of Labor presides over, of course, your FLSA, your wage and hour issues. They preside over OSHA for occupational safety and health, and they also administer the FMLA. We can get into that maybe a little bit more detail in this program. It may just need to be a follow-up as well. Part of my next follow-up will be FLSA, so we can address that then. So what are some of the initial changes taking place at DOL? Well, there's going to be a lot of changes. These are just the first. And so what happened is the Trump administration had adopted a final rule that was trying to, in some ways, let's say, clean up, and I say clean up the analysis of what it is. When is somebody classified as an independent contractor? A very big issue in wage and hour law, because if you have an independent contractor, then that person is not entitled to overtime. Well, if they're misclassified as an independent contractor, then the Department of Labor or a court could say you're in violation of the FLSA and you owe them, back pay, liquidated damages, etc. So this rule has actually been suspended. It has been suspended, and it seems very clear you suspend a rule because it's your goal to set that rule aside. And so the independent contractor rule that had previously been adopted during the Trump administration said, hey, look, what we're going to look at to determine whether somebody's properly classified as an independent contractor is the economic realities of the relationship. So if, and I won't go through all the factors, but it's a number of factors where it says, does the economic reality in the relationship between the two make the person more of an independent contractor, or does it make him more of an employee? And so we believe the rule that the Biden administration will come out with will be more likely to broaden what factors could be used to determine the person's improperly classified, which in fairness for my clients gives them less opportunity on the front end to proactively classify people correctly. And so I feel like it definitely puts employers who do have independent contractors in a little bit more jeopardy if they're at all close to the line, because there'll just be an expanded rule. That's not out yet, but it looks like this rule will be probably getting set aside. Let's move on. Okay, other significant developments in DOL. Well, DOL had issued another final rule under Trump that would limit joint employment liability. And joint employment is you have a relationship with another company, whether you kind of consider it a shared employee, et cetera. And so the idea was there will be fewer opportunities for the person that's not, let's say, truly the employer to face liability for, let's say, a wage and hour issue that's for the employee of another company. That rule has been suspended, and so we're not sure what's going to happen with that. But we would expect possibly that rule, since it's been frozen, to be revised and maybe go back to a broader joint employment standard where there's maybe more than one entity that could face liability for a violation. Of course, there's been litigation over every Trump rule, it seems like, just like there will be probably under Biden. It's just such a partisan environment, there'll be litigation over everything. Also, the DOL final rule on 80/20, if you're not dealing with tip pooling, then this may not have anything to do with your business, but I'm just saying this rule's also delayed. There was legislation that came out that was basically saying, you can have a tip pool and follows very specific rules. I do lots of FLSA stuff, litigate lots of cases, provide lots of advice, but let's just say this is another example of probably a more expansive rule where there's more limits on who can receive tip credits. than the Trump rule was. So the Biden administration is likely going to prefer a rule that limits tip sharing to an extent, especially if in requiring people to only be able to do that possibly when there is a situation in which you are already not just taking the tip credit. I could get into that in so much detail, it could take our time. Just trying to point out some Trump rules that were there that are being set aside. This kind of sets the tone for what we can expect in a lot of other areas as well. So let's move on. So we're talking about the DOL. So what is the DOL? We talked about the issues, but they conduct wage and hour audits. They're going to be if they felt like somebody made, like, let's say, a good faith error under the FLSA and maybe didn't pay somebody overtime correctly, they were willing to settle those violations without imposing liquidated damages, which doubles the amount of money the employee can receive. I read an article 2 days ago, and I actually talked to one of my partners in New Jersey who used to work at the DOL. And the information he was receiving was consistent with what I was kind of reading between the lines. It says future settlements for FLSA violations that come through DOL are going to have a mandatory liquidated damages requirement. So they're not going to even allow you to settle it unless you pay the full amount times 2 for liquidated damages. And so that's definitely something you got to look out for. It's time to get your house in order for your FLSA issues, wage and hour. Let's move on. So look, this is not a full list of everything you need to do to make sure you're complying with the FLSA. It would be a longer list. I do so much of this, I could get really detailed, but let's just be practical for this presentation. And that is, when it comes to your exempt employees, make sure they meet the duties test. I'm sure you've already made sure they meet the salary threshold. That's easy. Review the status of your independent contractors. If it's close to the line, dig into it, seek help, because you do not want to get caught in a misclassification situation that kind of bubbles over. Also, there's an agreement now where DOL is coordinating with IRS and other agencies to where if they find misclassifications, it's easier for them to share information, for them to say, oh, well, you may not have also been paying the proper payroll tax. So these can be cascading violations from one department to the other. That was typically not the case under the prior administration. So like I said, much more strict on investigations and aggressive enforcement. So obviously, every employee knows when it comes to non-exempt employees, you can't have them work off the clock. Protect yourself. At least have a policy that addresses off the clock work. That's an easy thing to have. It's something I put together all the time for people that don't have it. It's kind of almost at this point for me, an easy kind of almost cut and paste, change a few words kind of thing. It's just a matter of you need to have something that covers those bases. It can protect you when they do have those claims, and it can help prevent those from becoming collective actions, which is again beyond the scope of this overview. Pay employees correctly for call-in shifts. I call it call-in shifts. It's basically if you have employees who work on call, make sure you evaluate that situation and don't make mistakes there. There's a lot of little pitfalls. It's not all that difficult to apply, but there are some pitfalls. If you have tipped employees, make sure you're following all the tipped employee rules, which are in a state of flux, but be careful. And look, when it comes to all these issues under the FLSA, if you're not sure, just find someone to ask. I will say I'm dealing with 3 DOL audits right now for wage and hour, and also for H-2B compliance, which is also an issue they address. And it's interesting, they've really kind of taken a step back on the H-2B compliance, but now because we couldn't get the audit resolved during the prior administration, they're being incredibly aggressive in all the demands they're making for documentation that used to be a little atypical, at least under the prior administration. So there's a lot of ways if you get hit with one of those that if you've done some house cleaning beforehand, you could be in a better spot. So moving on. Okay, so we are to the NLRB. So National Labor Relations Board. One thing I always find interesting about the NLRB is employers that don't have unions think this doesn't apply to me. Well, wrong. And this is going to be the new administration is going to make sure that's the case. I can say that with absolute confidence because there's precedent for it with the with the Obama administration, and it was still an issue under the Trump administration to a certain extent. It backed off quite a bit. So the Republicans will maintain a majority on the board itself for, I believe it's like November of 21. The NLRB is different than a lot of federal agencies. And it's different in the sense that because people that hold the positions, they have statutory terms that are defined in the law itself about what terms they serve and when their term expires, which leads us to a very interesting issue that's coming up in a second. And that is, okay, so they have statutory terms and the board doesn't flip over to, let's say, Democratic control just because Biden won the White House. They have statutory terms. There was litigation under Obama about filling seats on the board in a certain way at a certain time, and all the decisions they made while that was the case were invalidated. And so moving on to the next slide, we'll kind of address that a little bit. So one thing that has never happened in history is that an incoming president from another party has fired the general counsel of the NLRB. It's never happened because the general counsel of the NLRB has a statutory term. So it's typical for the new administration. Well, it's not typical, it's unprecedented to fire the person, number one. But number two, it's never happened because the person has a statutory term. Well, on day one on the job, Biden fired the GC for the NLRB. Since it's never happened, it's a little bit of a gray area. But what do we take away from it? What we take away from it is precedent, okay, it's arguably not proper. Maybe it's a gray area at best, but it signals to me and a lot of the other lawyers that do labor work that Biden really has real intentions of using the NLRB as a means for pursuing his agenda. And he wasn't willing to wait until that term ran out to start making significant progress on moving his agenda forward through the NLRB. And what would that be? So what are we talking about then? Well, what does the GC do? Well, the general counsel at the NLRB gets to decide what cases get pursued. And so the changes that came, let's say, through the Trump NLRB were cases in which they were able to say, okay, well, we find a different outcome from cases, let's say, under the Obama board. And so we have some of those were, okay, we have expedited elections. We would expect to see the NLRB general counsel begin pursuing cases where there's an opportunity to, move back in for the quickie elections where elections take place super fast. Employers don't really have much opportunity to prepare. We would expect to see things like that. Expansive independent contractor liability. I mean, that arises in this context, IRS, DOL, and we would expect to see the new general counsel that was appointed by Biden begin to pursue cases that would overturn some precedent from, let's say, the Trump board, like Purple Communications. And I'll use as an example again, the Purple Communications stands for the fact that it's okay for employers to prevent their employees from using the email system of the company for anything other than work-related reasons. Well, why is that important? Well, it's important because if you limit that in that way, according, from, let's say, at least in the past, that means that employees couldn't then use your email system to, let's say, support an organizing effort, emailing all their other coworkers saying, let's support the union, let's support the union. Well, Purple Communications was an Obama era decision that said, well, regardless of that, employees are allowed to use your email system to organize. And so we would expect decisions like that to be coming through, and they have a general counsel in place. They're going to have a general counsel in place who's going to start pursuing those cases, so that as they work their way through the process, when they do reach the level of the board, there will be a Democratic majority that will have the opportunity to begin overruling Trump era decisions. And so the other issue I always think is, I'm probably going to have to do another program on all these issues as well, but handbook review standards. So Section 7 of the NLRA, I'm not going to get too deep in this, but it protects employees to engage in protected concerted activity for their mutual benefit. So even if you don't have a union, you have an obligation to not take adverse action against employees because they've engaged in protected activity under the NLRA. And so one thing that happened under the Obama administration is they began adopting rules that said, well, hey, if you have a confidentiality policy in, let's say, your handbook that prevents employees from talking about investigation, well, that chills speech and prevents those people from communicating with each other about an issue that may be of mutual concern, talking about pay or some other issue that would chill their ability to organize. And so lots of rules that have been in handbooks for decades started to become questionable and illegal under the prior administration. And so we would definitely expect to see a similar approach to Section 7 coming back, where you're going to have to take a hard look at your handbook and say, and your handbook can actually be, you can make some easy fixes in language to kind of make sure it doesn't run afoul of Section 7. Which, if you get a NLRB charge, one thing they're going to start asking for again is a full copy of your handbook. I always push back. There's great ways to approach it, but they always asked previously. They quit asking. Now it's coming back again, and so we're going to really see more focus in this area, focusing not just on union employers but non-union, because the idea being, in fairness, there's a view that unions help people, accomplish better employment, terms and conditions. And so anything that stands in the way of that could be a violation of the National Labor Relations Act. And so you're going to see more of a focus on trying to bring change to that area to make it easier for employees to engage in that activity and not feel like they can't engage in that activity. So it's easier for organization. And in fairness, that is the purpose, at least from somebody who does this professionally. So moving on, I really debated whether to address this issue under legislation or in this context. And I decided to put it here because this is actually the Protecting Right to Organize Act. It's the ProAct for short. It passed in the House in 2000. It just passed again recently. This would be the most sweeping changes to the NLRA, which was adopted in, I believe, 1935. And what it would seek to do is to codify in law a lot of the issues that normally, to change them, you would have to go through the administrative process through the NLRB, have to work a case through the process and kind of implement it like you would a rule. So what would it do? Quickie elections would come back. Joint employer definition would expand. Employees would have access to your email system for organizing efforts. One thing I think is just a really bad policy, and this is just me personally, is the idea of micro units. And I think it's a bad idea outside of the context of politics, just because if you have, let's say, a discrete department of 4 employees in one area, well, under the micro units, they could technically get together and organize and have a union representing the 4 of them. And then that could lead to another union coming in and focusing on a group, let's say a collective bargaining unit of 7 employees. And then you could end up with multiple unions representing micro units where, as opposed to saying everybody in a certain classification, those lines would be redrawn to make it easier for very small groups to organize. I think it just puts a lot of burden, and the cost associated with negotiating with multiple unions. It's something I'm doing now. It just becomes very difficult for employers, and I'm doing that not even in the context of, like, let's say micro units. That being said, I think that's difficult for employers, but I expect that, well, that's in the law. So if it were to be passed by the Senate, that's what people would be facing. Restrict individual employment arbitration agreements. I'm kind of reading these because there's a few things you need to know there. But the Supreme Court ruled in Epic Systems, I'm sorry, very detailed, that you can have arbitration agreements that limit class and collective actions, and that it does not, that any idea that it infringes on rights under the NLRA doesn't fly for that. And so they said that was fine. Well, if the legislation were to change to say it does offend that standard, then what we could be facing is new attacks on arbitration agreements across the boards, especially ones that waive class and collective actions. And so it would be a new avenue by which there would be a way to challenge and say this case belongs in court, and all employers that have adopted arbitration agreements obviously believe that that is a more cost-effective way for handling disputes on an individual basis. So anyway, that's kind of a good overview. And for unfair labor practice charges right now, those are handled through a streamlined process, but this law would make it to where there's civil fines associated with it that could go up to $100,000. So it would start all of a sudden imposing on employers obligations where you would be facing at least up to a six-figure payout for a ULP, which is not the case now. There's currently no monetary penalties. So let's think about what the ProAct, I want to show the reactions to the ProAct from various entities. I picked two that are just diametrically opposed on the issue because I think it's interesting. So the U.S. Chamber of Commerce, and in their specific language, it would undermine workers' rights, ensnare employers in unrelated labor disputes, disrupt the economy, and force individual Americans to pay union dues regardless of their wishes. That statement right there just means it's kind of an attack on the right to work, where if you don't want to be part of a union, you don't have to pay the dues. And then the National Retail Federation, very simply put, it's the worst bill in Congress. Now, moving on, the AFLCIO, obviously everybody knows a union, they describe it a little bit differently. It's the market they're appealing to. Just to be even-handed, I wanted to make sure I presented both approaches, but their view is it would protect and empower workers to exercise their freedom to organize and bargain. Also, it's a game changer if you really want to eliminate inequality and help promote wages and prevent wealth inequality. It's absolutely essential to doing that. And it's really, the ProAct would make it far easier for employees to unionize. It would give a lot of advantage to unions in the union election process and at all stages throughout the process. So they would have a real advantage in that context. So I guess moving on, there's so much more I could say about all these topics. We're trying to get an overview here. So Congress, it is the branch of government that everyone loves to hate. Everybody, it seems like, loves their own representative because they spend a lot of time shaking hands, etc. But as an institution, it's never liked for many reasons, it seems like. Well, I think this slide is self-explanatory. Everybody knows that there's a tight divide in Congress between the parties. And so that's going to play out in some challenges in terms of what can be passed under the current rules, et cetera. So moving on, I'm sure anybody that watches the news knows that. So we're going to talk about the legislative agenda a little bit just here in a minute. But in the meantime, these are some of the highest priority agenda items. And $15 minimum wage, everybody knows what that means. The ProAct we just discussed, expanding the Affordable Care Act and Medicaid particularly, The Equality Act hadn't mentioned that, but it would essentially provide, even though the Supreme Court has already ruled that, you know, sexual orientation is a protected class, this law would extend protections to LGBTQ, to all aspects of their life, including employment, housing, etc. And so there is some questions about how that would apply in the context of schools and elsewhere in sports and everything else, because how does it play out? Like with any new legislation, there's always gray areas. And so that's also a real priority. So these laws, as everybody probably knows, the $15 minimum wage could not be included in the recent stimulus, the American Rescue Plan, because it didn't meet with the definition of for conciliation, you know, which is something you can pass that with a simple majority, just because it relates to taxes and spending. This was, the parliamentarians said no on that, but if the Senate rules do change, I think these are some legislative agenda items that I think we could see passed. And I always do try to leave my opinions out of any presentation. And today will be no different, except for the fact that I will say that it has always been my opinion, regardless of who has been controlling in Congress. I've always felt like keeping the rules the way they were, and I disagreed with the idea of getting rid of the filibuster on Supreme Court justices in the past when it was a different majority. And I feel like it's the idea of, you know, in a way, the minority, you know, has a voice, and it's the idea is to force some compromise. I don't ultimately, whatever ends up happening happens, but I think that that rule has served a good purpose over time, and I'm hoping that it's able to be maintained. And I think, like everyone here, we'd like to see a little bit more, from both sides of the aisle, willingness to just discuss and engage. I did an internship in Congress when I was in college, and it was very interesting. Back in those days, whether you were a Republican, you were a Democrat, or an independent, everybody was friends, everybody spoke, you know, the congressmen went out together, they lived together, et cetera. And it was just much more of a cordial and professional kind of environment, not just based on sound clips. But I would love to see some of that come back. I don't know how that happens, but anyway, I think we're probably all hopeful for a less partisan environment. So moving on. Okay, OSHA. I just had to bring this up. There's going to be big changes in OSHA. I have in the past 12 months handled probably, I'm just going to estimate 40 OSHA complaints. And that's a lot in 12 months. The number of OSHA complaints has gone up dramatically because of COVID. And what's happening right now is before now, the strictest rules were being adopted by the state, let's say OSHA agencies, with penalties. So right now there is a focus on adopting strict standards to govern, let's say, and regulate COVID response in the workplace that would have penalties attached and be more enforceable than any of the other OSHA regulations that came out previously. And so that's a big focus right now, and we'll see what happens, because I'm very optimistic that maybe we could be turning the page somewhat soon in terms of at least, you know, vaccinations dropping this down, and then employers being able to open back up to an extent, et cetera, maybe in a cautious way, however the science supports. But we are going to see OSHA being more aggressive, more enforcement actions, more focused on whistleblowers and whistleblower complaints. And right now they have a massive backlog. So, you know, that's another difficulty. I have a number of cases pending with them right now, and some of them are, let's say, closer calls to an extent. But the other part about it is we may not hear back from them for a year and a half. And so that really puts you in a bad spot. So they're working through those, but now they're working through them much more methodically and carefully with more aggressive investigation. At least that's what I've been told by 2 directors of regional offices, that is a big focus right now to really make sure they do a very thorough job on investigations. So moving on. Okay, so there's been a lot of executive orders that have come out, some in the very early days of the Biden administration. And these focus on LGBTQ, apprenticeships, workplace unionization in the federal workforce, OSHA, COVID, immigration, asylum, women's health, Affordable Care Act. I'm reading these, but just give you an overview. I can't really discuss all of these in detail. I don't think that's helpful. But, one thing that's very clear is regardless of who is in office now, it seems like the trend is now for administrations to use executive orders to the fullest extent possible to implement their agenda, which in a lot of ways is just undoing what the prior administration did to implement something new. And just from a practical standpoint for me, I long for the days when everything wasn't so partisan, when it wasn't literally, okay, we're spending a ton of money to implement a policy just for 4 years later for something to come in and reverse it. And so maybe it would be maybe a little less partisanship in government would be more efficient. But once again, just kind of a general overview thought that I don't think is very controversial, that might just be kind of practical. But moving on. So immigration, I think it's interesting. I've gotten to the point where it's very difficult for me to watch news, but I've read quite a bit about what's happening in immigration. I will tell you, I am not an immigration specialist. I refer immigration matters to a number of our people in the immigration practice group who are fantastic. I know enough to be dangerous, but just to kind of give you an update on kind of where things stand right now with immigration. And it is, so everybody's probably familiar with DACA, which is Deferred Action on Childhood Arrivals or Children Arrivals in the US, which was, the idea was, okay, we're going to defer action under the Obama administration on deportation for children who arrived in the US. Well, Biden has already directed Homeland Security to preserve and fortify DACA. Biden had pledged to reopen DACA to new arrivals. So new children arriving, he had pledged that DACA would extend to them. To be honest, because it's not my practice area, I would need to do a little more research to determine what exactly is that policy. And I don't think DACA has yet been extended, but it is interesting to see the correlation with the pledge to extend DACA to new arrivals and what all that entails. There's also an expanded view on what qualifies as meeting the definition of asylum, like gang violence can qualify, whereas under some administrations it did not. And so, immigration, those are 2 examples. But the other thing that's really interesting is in one of my DOL audits, we're focusing on H-2Bs as well, because that falls under their area of review. It's interesting because the wage and hour audit aspect of that was all of a sudden is being super aggressive. The H-2B aspect of that investigation to see whether they complied with the H-2B rules, whether they can account for where those individuals are now who were here on H-2B work visas, is all of a sudden they've just closed that part of the investigation. They're not devoting the resources to that right now. So I think in some ways, you just see a fundamental shift, and it's a philosophical difference between the parties. I get that. We don't have to get into that. You all know that. But it's the idea of, to an extent on those issues, employers might be facing less aggressive enforcement on, let's say, I-9s and employing. It's not like Homeland Security is all of a sudden going to say if you're knowingly employing people who are not documented that you're going to get a pass. But I've just already seen to where they were less concerned. There were a number of violations, and they did not cite a specific client for any wrongdoing, which is fantastic, great, I get to look like a hero. I'm not sure that that would have been the case under the prior administration. So this will be an area I personally believe where there will be less enforcement actions. I think resources are being redirected to other priorities. So legislation, and I've touched on legislation a little bit, but let's just talk about some of these in a little bit more detail, or at least do an overview of them. And that is, everybody knows and have probably heard that family paid leave is something that's a priority. And so that's something, depending on what happens with Senate rules, and there may be some bipartisan support on that issue, at least from what I understand. So we could see some federal paid leave laws. There's already a lot of states and even municipalities that have family paid laws. And I know from a client that had me try to summarize them for the entire nation, it's a very difficult task. In a way, especially with employers who are everywhere, it maybe a federal standard would be easier, just so you could ensure compliance without having to check with, let's say, certain municipalities in California, and then what does the state law say, et cetera. But that being said, I think that that's a possibility. We talked about OSHA, COVID, more attention. There is very likely going to be, there's already some push to try to broaden anti-discrimination laws. We've talked about that with the Equality Act. Now, more stringent equal pay laws and a more strict enforcement of that. Definitely plan to see that. That was a big push under the Obama administration, and we fully expect to see a lot more equal pay, focus on equal pay. So that's definitely coming. Would not be a bad idea to do a audit of your payroll practices and where people fit in terms of, based on gender or whatever other factor, what your pay looks like. Some of my clients, when they actually do that, are really surprised by what they find. And it's not intentional on their part. It's just a matter of, they take a look at the audit and they're like, this isn't intentional in some cases. And overall, it doesn't show discrepancies from department to department. You can look at one department and it can look bad. And so anyway, that's one issue. So under the Age Discrimination and Employment Act, the ADEA, in order to prove a case and win it, you have to show that your decision, the only reason you made the decision was the person's age. Well, the idea is that's a little bit hard to prove, because if the person's performance was, let's say, declining to a certain extent, but they could show that age was somewhat of a factor, well, the employee still doesn't win because the standard is but for. So the idea would be for Congress to adopt an amendment to this law that would then allow for an ADEA case to be won by showing that age was just a factor in the decision, which would definitely expand liability for those types of claims. Legislation would be to eliminate the opportunity for employers to have mandatory arbitration agreements, class waivers, and collective action waivers, which applies to FLSA mainly. Minimum wage hike, we talked about that. As you'll probably recall, every employer was kind of scrambling under the Obama administration to an extent when there was the idea of raising the salary threshold for white collar exemption. We expect to see that come back. We don't know if it'll be to the same extent. And, I haven't heard any specific talk about it, but we've definitely heard about that. So the pro-worker union legislation, that would be the ProAct. We talked about it. One thing interesting as part of the ProAct would be, right now you have an election of people in the bargaining unit that determines whether or not a union is able to come in and has prevailed. One thing that the law would also allow now would be, okay, you have a certain number of people who submit cards. If you're not familiar with the process, I'm just going to be very general. And those people submit cards, which then get you to the point where it's like, okay, now we can have an election. Well, under some legislation, just the number of people who are interested in the union could possibly mean the union comes in just based on the cards they sign initially. And so it would kind of do away with elections. Not 100% sure how that works, because I haven't tried to read enough commentary, because some of this will not happen. Immigration reform is fully expected. I don't know what that's going to look like. I know there's a lot of news coverage, but that doesn't tell me anything about what the policies will be. And so we also expect new Supreme Court justices in the next 4 years. I mean, we've got ages listed there. And so, I think they'll not definitely, but there could be some opportunities for replacement. And that is already based on precedent from prior control of the Senate, in which the filibuster rule was lessened so that, nominees could pass with a simple majority. I've always thought that everything benefits best when it's even-handed and you just keep your rule in place for what it is. Not getting into that. Ultimately, it's just kind of one of those things. It is what it is. But we'll definitely see what happens. And I do think that just a key takeaway from today is the government agencies are going to be much more aggressive. Especially with the NLRB, the Biden administration has taken very aggressive steps to get their own general counsel in there. There's going to be challenges to that. But that being said, it shows that that's a major focus. There's going to be expanded investigations. There's going to be more focus on, let's say, enforcement actions as opposed to conciliation and mediation and resolutions. More difficult to get your issues that are identified resolved. And the best way to handle this really is to have a proactive strategy on the front end. So I guess moving on, I think I have one more slide. And so I did not make an effort to summarize the full American Rescue Plan. There's so much included in it. Obviously, everybody knows the $1,400 direct payments, the $400 enhanced unemployment that will have an impact on your workplace, probably to an extent, not to the extent that the other enhanced unemployment did when it was so much higher. But I know from speaking to all my clients that there was literally that created some issues with attendance. From what I understand, we've got OSHA protections, vaccine programs. There's many issues addressed in that, and so I will not spend more time on that. I think there's just so many articles on it. So I guess lastly, it's time to get your house in order. If you do a cursory review and find things you feel like are a little out of place, then address them before you have to address them with the government. And I'm not saying the government, I represent employers. There's no question about that. So it's easier for me to get something resolved if there's more of a focus towards mediation. If there's more of a focus towards, let's say, mediation, conciliation, if there's not, let's say, terms put into settlements, so such as, you have to post that you violated the National Labor Relations Act on a bulletin board and inform your employees of that, and then also inform them of all their rights under the National Labor Relations Act. Some of the terms that we were dealing with under, administrations ago. And so, obviously from employer perspective and the steps that you may have to take to resolve issues when they arise, proactive strategies are the best. And so obviously, we do this, lots of people do, but if we can ever be of any assistance to you, don't hesitate to reach out. I realize that this program takes up essentially our full hour. And one thing I'll say is if you have questions, please feel free to submit them and I can get back to you just on an individual basis and send those out. But thank you for attending today. I know it was a general overview, but I feel like that's really helpful before we start getting into the specifics and a deep dive on these issues. And so if you're interested in any one particular issue, don't hesitate to let us know, and or feel free to attend my upcoming webinars. But thanks for attending today. It's been great being with you.